That is a plural. Should we change its to their? These rules applied regardless of. It should be there. No, depends on his. It should be there. GIR. Yeah, you can use it even if it's not a person.
Chair, in relation to the fifth line in the second paragraph, the sentence that started, she noted the rule in the regulations for clarity, just to indicate education regulations, just include education. And it's capital E, capital R.
Madam Chair, if we could also just ask that when we're referring to regulations, if we just use a capital R instead of a common R, in general, always.
Accepted. We move on to page 5. Page 6. Page 7. Page 8. Page 9. Page 10. I think the last sentence that reads, the committee noted the provision would be further considered. It's the right way to put it. Yeah. Leave it as is. Yeah.
I'm not hearing you clearly, Minister.
I say on the last page, the last sentence says the committee, with regards to subclause 59.4 and 5, that the committee noted the provision would be further considered. And I'm just saying that that's the correct way to put it. All right. We will now move to the confirmation of the minutes of the meeting held on Thursday, March 9, 2023.
So moved, Chair.
Seconded.
Okay. Are there any matters arising from the minutes?
It would be in relation to the amendments, the clauses that need to be revisited. So.
Yes.
All right, so we'll move on to matters for discussion. The redraft of clauses 51 to 64, the first and second schedules, and the redraft of clause 4.1. So we'll pick up from where we left off.
So in terms of subclause 4.1, it's clause 4.1e. So that needs In terms of clause 4.1e, should I read A to D, or should I just read the new E?
Please read. Everyone should have a single sheet. Everyone has a single sheet? Okay.
So 4.1e now reads that the proposal is, this act applies to E, a person who teaches in an approved home education program, including a parent who teaches a child who is not his child.
Why at home?
So at home is to be deleted.
Madam Chair,
So I stopped.
I'm sure you know me well enough to know what I'm about to say.
His or
The
her
his,
child.
yes,
His or her child.
right? I'm on branch? Yes, the his. We need
His
to be
or
gender,
her
yes,
child.
yes. I was trying to be patient today.
Chair, are the drafters accepting that approach? Because given the interpretation of, and this is something I've raised over and over in the past, and the tendency has been to leave it as it is. But are we now saying that every pronoun here must have both the masculine and the feminine?
Madam Chair, can
Because,
I? Sorry, Senator Brown, but the last time I raised this issue in this same committee, I think it was the SG, I stand to be corrected, who stated that the drafting of laws need to be gender neutral at the moment, and that's what they aim to do. So yes, that was a response given a few meetings ago by the, if I remember well, the SG. Or legal reform unit, I don't remember which one exactly, but that was the response we were given at the time.
All right, so committee, I put 4, the amendment in 4E, 4.1E. So accepted?
Yes, Chair.
Okay.
In terms of 4.2, there is now a new 2B. So I'll read the entire provision for 4.2. This act does not apply to A, a person who teaches on an ad hoc, voluntary basis without pay, reward, or other consideration. B, a person who teaches his or her own child and no other child in an approved home education program.
Okay, I put 4 to B to the committee for confirmation. So confirmed. All right, Council, we will move on to subclauses 59, 4, and 5. Right? Which one? 59, what did I say? Because isn't that, there was supposed to be further consideration, right?
Based on my notations, I am to start from 56.
All right, please go ahead then, Council.
There was a change for 54D based on SG's proposal, but the committee did agree on that. So the next change is in relation to 56. (56)(4). This was in relation to the matter of the repetition of the word evidence. So we did look at other provisions in 56.4. So 56.4, the proposed reading is a person served with a notice under subsection 3 shall not be compelled to give evidence or produce any document which the person would not be compelled to give in evidence or produce in any proceedings before a court. So the word in was omitted from the provision based on provisions in other legislation. Specifically, I looked at the sexual harassment legislation. Yes. Chair, taking the committees accepting that change? The next provision is clause.
I put 56.4 to the committee for confirmation. Yes, all right, so confirmed.
In relation to clause 57, right of representation, the proposed clause is a party to an inquiry may be represented by a body which represents the majority of teachers in Jamaica, an attorney at law, or any other person, or may elect to be self-represented.
All right, I put clause 57 to the committee. All right, so confirmed.
Question. And I know this may have been discussed last week, but just for my own clarification. If the person a party to an inquiry is represented by the body, does the body that represents the majority of teachers, instead of an attorney, does that representative on the council who is there for that body then withdraw themselves from the proceedings? And is that ethical? I'm just asking those who do labor relations. I'm asking if the person in 57, a party to an inquiry, is represented by their union, but their union sits on the panel as a member.
I don't think the union would be a part of the PPCC. The union,
yes, they are.
The PPCC, by the council?
I stand to be guided by the technical team, but yes, they are. And the PPC has a membership of how many persons? Please remind. 5 persons. And the quorum is? There's no quorum for PPC, so 2 of them can sit. So, oh, it's everybody, sorry. Everybody sits. It has to be all 5 at once. So is it ethical then for the entity to represent the person to one of their own members? It's a conflict.
There's a Senator Gill there, but this happens all the time. The person who is nominated by the majority association is not directly involved in the case, but is allowed to hear the case. It happens all the time, and it's not a conflict that would remove the person. But I was waiting for Senator Gill if he was there to comment.
Yeah, I'm here, sir. And
bless you, Liverpool.
it has been an entrenched practice. We have never seen any conflict because the person, whilst nominated by the association, is not in any way involved in the case itself. And so it's hardly likely that any conflict may arise. Take the Industrial Disputes Tribunal, where you have both an employer rep and employee rep. The employer rep is normally a nominee of the Jamaica Employers Federation, and the employee rep is normally a nominee from a trade union. And you would have had situations, Member Brown, where even the trade union representing the group of workers or that individual worker may appear before a panel with a nominee representing the worker that would have come from a specific union that is representing the worker, the aggrieved worker. So it's an entrenched practice that one has never borne conflict nor challenged in that case.
In light of that intervention, I put clause 57 to the committee.
Agree.
So confirmed? So confirmed? Yes, yes. All right, thanks. We'll move on to clause 58, disciplinary orders, results of disciplinary inquiry.
Just, yeah, go ahead. I have a comment there.
58(1)(c) was the change. Chair.
Just to be clear, Chair, under 58, there's no absolving of the person against whom a complaint has been made as one of the likely outcome from the PBCJ.
I agree with you.
I also agree with Senator Brown. You might have snow.
It may be a part of the submission coming from the representative, but I believe that it should be outlined as a consequential effect.
It would appear to me that they just need to insert that outcome, and it's done in other pieces of legislation where the committee's outcome, the possibilities of the committee's outcome are noted, and one of which is that to absolve the person where the evidence does not so support. And I believe it might very well have been somewhere in the draft, but just for certain that that's an outcome which is likely. Otherwise, there would be no need for a hearing.
All right, so thank you for that, Member Brown. Council is looking at it right now.
Member Brown, you notice how they flow in terms of the gravity or weight of the sanction. So it starts with the lighter one in terms of the warning, and then it graduates. And then what you'd be suggesting now is that that one that should be first, in my mind.
I'm with you, Senator Gill.
Chair, with your permission, I will allow can we allow Ms. Sherland to make that draft, and we take 58(1)(c?
All right, I put clause 58 with the amendment. Are you going to make it now, Ms. Sherland?
I'm to
For C, for C.
Let's see, you're going to make the...
So there was an amendment to be
wording?
made to 58(1)(c.
Right. But is it going to be done now on the
Right,
floor?
and-
Okay.
Whilst allowing Mrs. Sherland to treat with the part where the person is not
Absolved.
found
Yeah,
guilty.
okay.
And if it is that that will come first, now this 1C will now be 1D.
I don't know if it's okay, since C is going to become D and we'll have a new A, can we just wait and do 58 as a whole? Or
58(1).
Yes, 58(1) as a whole, once the change come in. So we just leave 58(1) for now. Just do one tidying up.
May I, Chair, suggest that there may be the need to tweak the preamble at 1, where it says, upon an inquiry conducted under section XYZ, may depend on the nature of the seriousness of the complaint. So you probably need to say where the complaint is not found, that, and then depending on the nature of the thing, the other course outline would follow.
So you would be seeking to separate the actions then?
That's one approach. It's subject to the draftsman, because I know other legislation does take into account that the absolving of the person and trial.
But that's a decision, though, Member Brown. Why would we want to separate that out?
This is why I'm saying, I'm not saying separate. I'm simply saying that we need to find it in, but it doesn't arise from the severity, depending on the nature of the seriousness of the complaint.
But it says or, depending on the nature or seriousness of the complaint. Or, yeah.
Where's the R?
Yeah, it's right there.
I think he has the old version because he also left out the other thing that was amended there, the Council Professional Practice and Conduct Committee. He didn't read that, so maybe he's using an old version.
All right, Member Brown, can you look in
But
your
if
email?
it's there, I take your word and I take that of the lawyers there. So I'm not going to oppose it.
All right, but
If
Member
it fits
Brown,
in,
right?
and
Take a look.
it's fine with me.
Take a look in your email for the latest version that was sent out.
Sorry, it came later. I just asked my office to print it
All
for me.
right, no problem.
can-
Yep, thank you.
Yeah.
Mr. Foreman, please go ahead. Okay, I'm sorry. Mr. Foreman, did you want to say something? Do you have an intervention?
Yes, I'm being heard now, right? Yes. So, as a discussion, a possible way of approaching the clause is to say that the PPCC may dismiss the complaint and then depending on
Not
the nature
hearing,
of
Madam
circumstance.
Chair.
Sorry, Mr. Foreman, we're not hearing you clearly. I don't know.
Okay.
All right, speak without your video, please.
All right.
Let me try again. Oh, this is better.
It's better.
Okay, great. Yes. Right. So my recommendation might be to say in the clause that upon an inquiry, the PPCC may A, dismiss the complaint, then B, depending on the nature or seriousness of the complaint, make any of the following decisions, and then the rest of the provision flows as is. Well, there might be some further renumbering, but that's a potential way to approach the comments that were raised by the members.
Yes, Chair, that was the suggestion made to the drafter, so she just needs the time to put that wording for the new 58(1)A together. In terms of 58(3) and 4, the Professional Practice and Conduct Committee shall issue a report to the Council, which includes A, the decision that has been made, B, the reasons for the decision, C, the date that the decision takes effect, which shall be no earlier than the date that the notice is served, and D, the period that the decision may remain in force under Section 61. 4, pursuant to subsection 3, upon receipt of a report from the Professional Practice and Conduct Committee, the Council shall, within 7 days, serve a copy of the report on A, the registered or licensed teacher or instructor who is the subject of a complaint, and B, any person employing a licensed teacher or instructor who is the subject of a complaint. So that's the new 58, 3 and 4.
So the report wouldn't go to the complainant as well? Did I hear that? Because I heard just the person who is the subject of the complaint and then the employer. And I was asking if the report wouldn't go to the complainant as well. But not the complainant, right? It wouldn't go to the complainant? No? What if the decision that has been made offends the complainant?
Where in it are they notified, though? Because they should be notified of the decision. Which section says we notified them? Because I can't remember that because I believe they should be notified, but a copy of the report may actually have things in it that they should not be aware of, because what if the complainant is John Brown off the street who has a problem with that particular teacher, and you know the discussions, so I think they should be informed but not necessarily get a copy of the report for privacy reasons.
Because a report of that nature, having gone through an investigation, may identify certain other deficiencies surrounding the particular institution which a person outside making a complaint has no business to be aware of. And so the important thing is that the person making the complaint should only receive the decision.
Agreed.
If they want to appeal that decision, then there's some other process that ought to deal with it. But this particular area is treating with an outcome that the institution involved should be aware of as it relates to the report, and the registered licensed teacher or instructor who is the subject.
But the institution in and of itself won't right, but the employer won't necessarily need a report either. The employer as well as the complainant may just be notified of the decision. But then the person who is the subject of the complaint is given the full report.
And also we need to identify where in here it says the complainant will receive confirmation that, you know, something to show what the result was. I can't find it because I don't remember seeing it, but we need to ensure that is included. And I do support what Member Hamilton is saying, that maybe we do need to change B, where the employer, and I'm assuming here, based on how the Education Act was written before, a teacher in a public school is actually employed by whom? Is it the board or the ministry or whom? The board. I don't think the board should get a copy of that report. I think they should be informed of the decision, but I'm a little wary of them receiving a full report of what happened in the deliberations.
I have a different view to that. Sorry. I have a different view to that, because here's the situation. The institution or the employer would have been privy to the complaint and would have been aware that an investigation would have taken place. And so that investigation, based on what I would have indicated earlier in terms of the investigation identifying other deficiencies, it would be helpful to that institution or employer to be privy to the report if they need to make remedy or amendments to any other changes in relation to their operations.
Agreed, but then the section that is relevant to that should be made privy to the institution. However, there may be other things in it that may prejudice against the defendant, for want of a better term, the teacher, that maybe the school board does not need to know. So I'm just saying, give them a result, and if there's something in the findings, I don't know if it can be done that way, where there's something in the findings that the school needs to be aware of, then they are, but it's a little tricky with privacy matters to hand over the full report to a school board.
Chair, through you, I think a policy decision needs to be taken whether or not the reports from the professional practice conduct committee should be public. And by public, I mean available to the public. It doesn't have to be published, but if a request is made. So that would address the issue as to whether a complainant wishes to have sight of the report or other persons. And so, for example, I'd love to know, and I think I have a sense, what would happen if the General Legal Counsel or the Medical Counsel was to establish a disciplinary action against somebody? Is that report generally available to the public? And therefore, maybe we use the same standard as this. Senator Gill and I know that the Industrial Dispute Tribunal, the hearings are public. I don't know if this committee hearing is going to be public. It is public, and the result, while not published in a gazette or so, is available to whoever may seek it. So a policy statement having regard to the current practices may be a useful decision that we should adopt before we decide whether this one gets it or not. The other thing that the lawyers may be interested, may wish to respond to us on is the complainant and quote unquote, as the civil procedure rule says, a interested person or a person directly affected, or it's just that this is somebody who have made a report but is not directly affected, because we have laws that addresses these issues. And so maybe a policy position would be useful in deciding, is it public? Is it restricted? So that will decide who gets it, including the complainant. Those are just my views.
Member Hamilton?
I think I tend to agree with Member Brown in relation to a policy decision being made surrounding the report, if it should be made public or not. So I think it's something we should ruminate on. The suggestion was made for us to review how the GLC operates. I think that would provide some clarity or guidance.
All right, so we'll leave that with council to come back to us. All right, carry on. Sorry, go ahead, Mr. Foreman.
Yes, thank you, Chair. I'm not sure of the extent to which any council can advise on this. It's in one part, it's a policy decision. The legal aspects to it involve the fact that there's a constitutional right to access information. I would imagine that the Access to Information Act, absent a specific language in this legislation to say that these reports are not public, would empower an individual who wants to know what the PBCJ has been doing to access those documents. One can go on the website of the General Legal Counsel and see decisions in relation to disciplinary matters that have been brought against attorneys. I can't say in this moment whether that applies to other professional bodies, but I would imagine that an access to information request would be effective in getting any such decisions from those entities. There's also the consideration that these decisions are public in the sense that the council will be exercising authority given to it by the Parliament, acting in the public interest to ensure that persons are disciplined appropriately for any wrongdoing they may be found to have done. and that these decisions do set precedent, because they will inform the standards that will be expected of teachers, and allow for the profession as a whole to understand what what conduct is appropriate and what is not appropriate. So a large bit of this is matters for the committee to assess, and I just add that by way of contribution.
Mr. Foreman, am I understanding that as part of the options that you would have given suggest that whilst the information may not be given voluntarily to the public may have access to it? So in other words, we don't have to make the report public, but the report is public because there are accessibility to it.
I've sent specific language to the contrary in this legislation. It would be difficult for me to see and access the information request, for example, being resisted in relation to a report that the PBCJ makes in relation to a specific individual.
Well, I'm trying to ascertain from your guidance where the legislation can align itself to policy to determine the policy direction.
But I think in addition as well, yes, there is access to the information, but the legislation, what we're debating is whether or not the legislation should offer it. I am not, nothing in what I said is suggesting that I'm saying there should not be access to it. What I'm saying is don't hand it to the employer or the complainant. I believe the complainant and the employer should be told the results of the investigation. And if there's something, if there's a red flag that the employer needs to be aware of, then I think that should be a separate report taking out that red flagged item. But I'm just a little bit cautious about handing over a report. I'm not saying block access to it. That would be a policy decision, Minister. If there's some reason why we believe, you know, the executive, if through yourself you believe that it may need some thinking through, I think. I don't think it's something we can decide today because it's a tricky one.
Before you, I'm just picking up on something that you would have said, Senator Brown, where you establish the difference between a party who has interest as opposed to someone affected. And maybe we have to consider taking that into consideration in making the policy decision.
Yeah, I'm a little clearer by what Mr. Foreman said. As I understand him, he's saying, one, the government general policy is towards access to information. Secondly, the practice of a body, a professional conduct body like the General Legal Counsel, has been to publish on its website the decisions. And as I did say, you know, I'm aware, because I've seen some reports from cases where that happens, and I suspect the same for the medical thing. So there should be nothing that we include in this, which says certain people can't get the report. And then I raise the question of interested parties, Senator Gill, because again, if the matter goes, a matter like this, that we put a law in place saying this is the process of hearing, then the person who is affected or an interested party may want to consider judicial review, that is to say, appealing to the courts through the process of judicial review. And at that point, the courts may decide whether Senator Gale or I is an interested party, or are we directly affected? And there's a whole process that the court set up relative to judicial review. So again, maybe just to pause and get a sense of what flows if judicial review is an opening from such a panel. And if that is an opening, then all the natural things that flow from that, the right to see the report, I think would flow. But I'm not a lawyer, and so I'd love to get a sense as to what if judicial review being excluded? I suspect not. And if it is not being excluded, then the normal, as the AG, as the Solicitor General would say, the normal common law practices would flow.
And that normal common law practice would be what, Member Brown?
That people would be entitled to see the report, I would say. So if it's a complainant or it's a school board or the employer in a private school, because I think this also applies to private school, who we call other employer. So I'm not going to say anything that, and I don't think anybody here is saying block anybody from getting the report. The report should be accessible. It should be given to the complainant, to the person who is charged, and it should otherwise be accessible on request. That will be the approach I advocate at this point. May I just add that the committee, the Professional Conduct Committee, can, in drafting their report, do it in such a way, Senator Campbell Rodriguez, to take into account how they report on quote-unquote sensitive issues. Such a report the report can be drafted to take into account that. It's not necessarily redacting anything, but writing it in such a way that it doesn't have to say everything, but it could point to issues which it finds.
Chair, I'm trying to review the Legal Profession Act as it relates to the GLC. It is a completely different kind of model because the report or orders or directions that come from the GLC are actually filed with the registry or the registrar, and it is published in the Gazette, which makes it public. Anybody who wants to inspect or make note of the directions can do so at the Registry of the Supreme Court. Now, that would be a totally different model from probably what we would want to do. So we have to take that into consideration as well. So the legislation itself indicates that any order or direction coming from the GLC must be published in the Gazette, which makes it public.
Well, I think at the very least, the report should be made available to the person impacted.
Madam Chair, that's what I suggested as well, and I think it's the same thing that Senator Brown, that the person who was the subject of the investigation should receive the report. I don't believe it should be given to anybody else, but they can have access.
But Chair, but in terms of the employer, a mere notification of the decision would not suffice, in my opinion, because the employer is also going to be affected by the decision of the council. The employer would need to know the date that it takes effect and the period in case of a suspension in order to know when the teacher is expected to be back.
Yes, but you can give that information without giving a report. So those basic information, I assumed, that if you said you're going to inform the employer and the complainant, you'd give the basic information that X person will be suspended for 6 months beginning March 16th to September 15th. I just assumed that those basic information would be provided, but to give the full report, I'm not. The deliberations and all of that, I just think it's...
So you're saying if the board wants the report, they can make a request of the council?
Because even based on what Member Hamilton read, it is a situation where the interested party would have to request the document. It's not just handed over to all the persons, am I? Yes. For the JLC, it's not that they're given one.
So I'm going back to reading 58.3, which speaks to the Professional Practice and Conduct Committee shall issue a report that speaks to A, the decision that has been made, B, the reasons for the decision, C, the date that the decision takes effect, and D, the period of the decision may remain in force under Section 60, subsection 1. Now, if all of that is contained in a report that flows into 4, it's important in my mind that me being the employer should be privy to that information, because it also identifies the actions that will be taken. And so it's a little difficult to accept that it only should be issued to the person to which the complaint has been made, when the employer has a fundamental responsibility to carry out certain actions in accordance with the decision. The decision that has been made, the reasons for the decision, the date the decision takes effect.
Madam Chair, I think we should seek some advice on this matter, because it is a little bit tricky to just provide the employer and the complainant with the full details of what took place in the deliberation. We have to, I think this should be taken under advisement from the perspective of privacy for the teacher.
Member Gale, in your proceedings, well, I think Member Brown said these proceedings are public. But I'm asking, in your proceedings, what happens to the report? What's the root of the report?
But a tribunal award is very detailed and explicit. That would give or make reference at times to the issues and events around the dispute. And so the award is provided to the worker involved and also to the employer. But it's a public document where anybody can have access to it. And so it's under normal circumstances in this case, what is being suggested is that the institution involved, who is the employer, gets the report, and the aggrieved worker would get the report. I'm trying to ascertain what is it specifically that may be contained in such a report that either party should not be privy to.
Member Gale, I'm thinking, and Member Rodriguez can correct me, I'm thinking that Member Rodriguez is thinking that the report is going to be the detailed report of the back and forth and all of that rather than a summary of what took place in the meeting in order to get to that decision. I don't think it's going to be, he said, she said. It's going to be like minutes of a meeting that really focuses on the important points in that meeting rather than Mr. So-and-so said this and Mr. So-and-so kiss his teeth and walk out of the meeting. You know what I mean? I don't think that kind of detail will be in there.
No, I agree, Madam Chair, that we may not have it's not verbatim to take, I agree with that, but we have to remember in this instance, which is why I asked the question, who is the employer of public schools? The board. Who makes up the board? These are random, sometimes in some instances, random persons who are neighbors to even the complainant or the person affected, and we have to be careful. But remember,
on the board, though, when you go to the disciplinary matter, it's not the entire board, right? It's a committee of the board,
right? But we don't know who's on the board.
With very specific persons who would deliberate.
But the whole board has.
And if there is someone who would be considered to be prejudicial to the situation, they can't be on that committee.
No, Madam Chair, if I remember well, for boards, even if something goes to a committee, it then has to go to the whatever decision is taken by the committee, it has to go to the general body. And the person is there. And I'm not saying block access to the report, Madam Chair. I'm saying do not voluntarily hand it over, because we're talking about privacy matters. And all I'm asking for the committee to do is to let the legal team do some research as to what privacy matters might be. And colleague, Member Hamilton is reading through the GLC to see if there's something there, because we have to be careful about just handing over these details. Just look at our privacy laws first as it affects individuals before we sign off and just handing this report over.
Chair,
yeah, but look at what is included, the decision that has been made, the reason for the decision, the date, and so on. It's not...
Chair, the reasons for the decision is the part that has me a little... That's the part that... And that's what I'm saying. It must go... No, and I'm not saying it shouldn't be. I'm saying it must be in the report, which is why I am saying, do not hand it to anyone other than the person who was before the committee, and anybody else has to request it if needed, but to just hand over a report like that, let us just do our due diligence.
But Minister, Chair, the thing is, in terms of a board, the board members would be subject to some level of confidentiality. And also, yes, and also, for boards, remember that they too carry out disciplinary actions. And so they too carry out disciplinary action. It's just that there are some circumstances where the council is going to treat with it through the PBCJ, or the board is going to treat with it themselves. And there are sometimes situations that might be very similar in nature. And so I don't see why, and also the fact that the person is the employer, why you could not provide that to the employer. I don't see the reason.
Member Hamilton.
So I'm looking through the fourth schedule of the legal profession disciplinary proceedings rules at 14, and it's quite instructive. It says, the committee shall hear all applications in private, but shall pronounce their findings and orders in public. So there's a distinction in terms of details of hearing. Right, the blowback, right.
Right,
That's
that
private.
was not being the report.
So, but as was
No,
highlighted
if you spend
earlier,
a week going through this, you're not going to generate a verbatim report.
the report that we're referring to here would not include the details of the hearing. It would simply include, as you were saying, the reasons for the decision, among other things, the sanctions being. So, do we want to adopt a similar stance for the PPCC as we see here for the General Legal Counsel, where it is said in their rules that the application is in private, the hearing of the application is in private, but their findings should be made public?
What is included in their findings? What is included in their findings? That's what we need to know, I think, before we can. But all I'm asking
But it's right there, the decision.
No,
the
I mean for the GLC, Madam Chair. What's including in, because it says the findings are made public, but what is included in the findings? All I'm asking for is just some research on this, just to make sure we're not setting ourselves up for something.
And Chair, in terms of attorneys, whilst you know, the level, the duty of care in terms of carrying out your job functions as an attorney is different from a teacher, but also to note that you have attorneys who work for themselves. Majority of teachers who this bill is going to be applied to are employed by the government, and also the differences for lawyers as against teachers, they're not the same.
May I ask a
Yes, so
question?
in terms of application.
But may I ask a question, Madam Chair? May I go ahead and ask? Okay, let us look at a scenario that I'm making up in my head as we're talking, yeah? So let us imagine that Miss Brown, who is a teacher, there's a complaint against Miss Brown for sexual assault on a student. Okay? Miss Brown, from the deliberations, there wasn't enough evidence or whatever reason, Miss Brown is absolved. And that report goes to the board with the reasons why she was absolved. How would that work? In terms, I know we are not thinking of it as a regular board. A school board should not be thought of as a regular board. A school board is generally, in the most instances in Jamaica, very community-oriented. So imagine this happened down in Moko, Clarendon, for example, a small, tight-knit community.
All right, so Minister, in terms of that, remember, in terms of the sexual assault, that would obviously be a criminal matter. And so based on the provisions of the act or the bill now, it would not be for the council to treat with. It would be after hearing that matter, then they would not be the ones deliberating on that case. It would be for the court.
Right, but it would go, let's imagine that it was reported to the council. They have to respond. The council would have to respond even though they refer the matter to the court. And in order for them to respond, a report would have to be written.
But wouldn't that report say referred to the court?
Maybe. Maybe. But I'm just saying, Madam Chair, that we have to be mindful of how school boards operate. They're a community. Usually it's, if you're looking, especially the parishes outside of KCC and Montego Bay, it is community people getting together.
Chair, I'm actually concerned. I'm concerned about school boards being different. That a board is a board, no matter its composition and the geographical spread from which it comes. Secondly, I don't think it is intended, but I hope we're not feeling that teachers are a lesser profession than lawyers.
No, Member Brown, absolutely
No member
not.
said that.
No,
Yeah,
nobody said that. Nobody
I
said
hope
that.
that's not what is intended,
No,
but
there's no
I heard something
intention.
a while ago on which people could...
No.
Not from me, I hope. Not
There's
from me, you didn't hear that.
No intention of that, Member Brown, please.
I'm a part
Don't
of the meeting.
draw
I
any
heard something,
inferences.
and I'm just simply saying, I hope we're not of the view.
You did not hear that anywhere, Member Brown.
Minister,
You did not hear that anywhere from this committee.
I heard it about the GLC and teachers are a different thing. So suffice it to say, if the committee is of the view that teachers are not a lesser profession than lawyers, then I'm fine with that because that will guide
the committee never in any way, shape, or form suggested that.
I know, I understand your nuance on that, Senator Gill.
No, it's not a nuance. It's not a nuance. It's a fact.
It is a nuance, but you said the committee, and I agree with you. And the committee is the members of the parliament. I understand. I'm not going to make a big issue because it's clear it's not the intention. I just caution against it. But again, I come back. We have the view as that the report should be public, available, not necessarily distributed to everybody, but available. If that is so, then the lawyers can fashion the wording that gets us that objective. Right?
We agree that it should be made available. It should be public. We agree with that.
So then we probably should leave it to the lawyers, the drafters, to give us a draft that achieves that.
No, I just want to clarify what I'm asking for. I'm not saying it should not be public. I think it should be made available, but it should not be distributed. That's what I'm saying.
Because there's a...
So here it says it should be distributed to, let me put on my glasses here. It should be distributed to the teacher and the employer. And then the question was also raised, should it be distributed to the complainant? And I am saying it should not be distributed to anyone except the teacher. But it should be, yes, but it should be available. I'm not saying it should not be available. It should be available. Access should be there, but we should not distribute it to anyone other than the teacher.
Yeah, I beg to disagree.
How would the employer know? How would they know?
Madam Chair, I think the employer should get the information as it relates to any action they need to take. That's it. But I don't believe the reasons. B is my concern. B, the reasons, because I can write some reasons that give you every detail. So you have to be careful when you talk about, that's my concern, the reasons.
Chair, just to go back to, in terms of the criminal matter that you had raised earlier in relation to the sexual assault, you had indicated that if it comes to the council's attention, then the council would conduct an inquiry. Is that my understanding from what you're saying? Because based on the provisions of the bill, if the person is charged with a disqualifying offense, which would be the sexual assault, then the action for the council is for suspension. They may suspend and then wait for the matter to be determined by the court, and that's set out in section clause 60 as to how long the suspension
Notice the
will
word
take
you
effect.
used when the person is charged. You said if a person is charged. Quite often there is no charge. So imagine a situation, there is no charge against the person, but the parent is adamant that something was done to their child. There is no charge.
But
because before you can bring a charge, there are many things that need to happen. So, and that's where I'm saying the legislation talks about a charge. So something can go to the council that is seen as a criminal act, but the person wasn't charged. And as written, the legislation talk about having been charged.
But
we're getting a bit technical now, Chair, because if you're going to go into acts of that nature, you know, I think there is a legal responsibility to report certain offenses. I think we should just stick to what we have here, because if we get into this, we'll go into some difficulty. Yeah.
Chair.
So, go ahead.
I am for sticking to what we have here, because look, if there's a basis for the employer to take an action, the employer will have to take the action based on the reasons presented. And so the employer would have to be aware of the reasons. And further to that, those reasons may be helpful in future guidance in relation to policy direction of an employer or the stipulation of rules. And also for a worker, another worker may want to, in receiving any sanction, be aware of the precedence that has been set with an earlier sanction to determine if the employer is reasonable or fair. Now, if the employer don't get the reason, the employer wouldn't know what to determine in terms of future actions. No, man, don't make it so cumbersome. Don't make it so cumbersome.
But also as...
The employer has to be notified. They
yes.
have to be told.
But also as a part of public law, the administrative actions of an entity, I think it requires now that reasons be given for the decisions to ensure that the process is fair. So we can't go around giving reasons for decisions at this time. I do understand the concern of Senator Campbell Rodriguez. We probably just have to find another way to ensure that persons who interface, persons who we appoint to boards are responsible, and that persons who would interface with information as this, you know, would treat it accordingly, as, you know, with confidentiality.
Madam Chair, all I'm asking for is a review of what our privacy laws say before we sign off on this clause. That's all I'm asking for, just to be sure we're on solid footing. Just review, just the legal team just review privacy issues. And if the law is clear, I will stand down on the issue for sure, without any doubt. I just want to be sure we're on solid footing, because we have not found another legislation as yet that is doing this. So maybe there is but we just have to be sure. That's all I'm asking. Let us be sure.
Hear what you're saying, and I understand what you're saying, but I wouldn't want us to make a provision in law that may assume an approach of subjectivity as opposed to being objective. And this approach may give that assumption. It's better we are targeted in what the application ought to be and try to manage the subjectivity part of it. As referenced earlier on, board members are expected to insinuate some sort of a discipline as it relates to confidentiality. And there are certain governance practice that promotes that.
I agree with you 100%. On the flip side, I'm just asking, let us just verify within the laws of the country if this violates anything. That's all I'm asking for. Just check.
Or remember, I'll just ask the technical persons online, Mr. Foreman, SG, anyone who would like to present what our privacy laws say about this situation? Go ahead, Mr. Foreman. You probably want to turn off your video.
Yes.
So we can hear you.
Nothing comes to mind immediately. As I indicated earlier, from an access to information perspective, a document such as this would be something that's available to the public. And if that is the case, it's not clear to me that a provision that says a specific category of person must receive the decision, as opposed to them having to take their own initiative to get the same document, would run afoul of any other data-related legislation.
All right, thank you. Member Rodriguez, I'm going to put it to the committee that we accept that the report of the findings be given to the licensed teacher or instructor who is the subject of the complaint and the employer. So confirmed members. All right, so yes, I'm putting it to the council that the report, the summary of the report from the PBCJ
would have raised the concern and that would be recorded.
It wasn't a concern, it was a request that they look at the law first, Data Protection Act.
In addition to your concern,
But Chair, just to raise in terms of providing the report, you recall that under clause 51, there are instances where the board may request the PBCJ to conduct the hearing on its behalf based on the I guess based on the seriousness of the matter, I think it cannot treat with it. So in that case, they would need to provide a report of the decision so that the board can know what was, or the employer can know what the decision was. But if you exclude it here.
No, but even now, when boards appoint disciplinary committees, they deliberate and they come back to the board with their findings. That's how it works. So I'm really
what
not
about the
seeing...
church that owns some schools, where the employer is the church? So we're talking a lot about the boards, but what about those schools? No, but I'm saying we said the board is supposed to operate in a particular way, and the board is governed by whatever. But what happens when the schools are owned by private entities or by, for example, a religious group?
In terms of religious group, there are religious groups that are public, that own public schools. You're talking the private ones. Well,
the argument has been made to say schools have boards and boards should be asked to operate in a particular way. But what happened to schools that the employers are not boards? But the employers are not recognized as the boards necessarily. In the public schools, the board is the employer. In the others, are the boards the employers, or is it the church? All I'm asking for is just a little more research. That's all.
Okay, members. We will oblige. Let's do some research and come back. We'll move on, Council, to 59.
Chair, just before we move to 59, just want to draw the committee's attention to clause 67. Yes, it's a provision that we treated with before. No, it's in the general bill. Specifically 67D, based on the discussion we had at the last sittings, and the recommendation and the acknowledgement by the committee of a like clause under 67(1)D that says, in the absence of any party duly notified to attend the hearing in the matter which is the subject of the complaint may be decided by the tribunal ex parte, based on the decision that was made to remove that clause, a similar clause last week. I am proposing that it obtains for this provision as well.
Oh yes, take it out of 67. All right. I put that to the committee, the amendment on 67(1)D. All right, so confirm.
And in terms of 69(4), it's also a like clause in terms of the giving of evidence. I am proposing that we also insert the word in. Between give and evidence. So it should read, a person served with a notice under subsection 1 shall not be compelled to give evidence or produce any document which the person would not be compelled to give in evidence or produced in any proceedings before a court.
I put the amendment to clause 69(1)(4) to the committee. Committee members, so confirmed.
Madam Chair, a random point. 67 that you just brought to our attention, you have 67(1), A, B, C, D, but there's no 67(2). For example, it's the same situation in 53, where you have a A, B, and C and no 2, and it's just 53 A, B, C. Is there a reason you have a 1 at 67 that you don't have at 53? Because I'm wondering why you have a 1 when you don't have a 2. It should be deleted? Okay, thank you.
All right, Council, we move on to clause 59.
(59)(1). Where a registered teacher, a licensed teacher, or an instructor has been charged with a disqualifying offense, the Professional Practice and Conduct Committee may suspend the registration, license, or authorization to teach, as the case may be, held by the person. Chair, last week we took this provision. However, when the technical team met, we saw that it's not the council that would take that decision. It's the Professional Practice and Conduct Committee. And so we changed the word council. The proposal is for, based on the dispensation, it should be the Professional Practice and Conduct Committee and not the council.
All right. Okay, committee members, 59.
And that's the same for 59(2).
Yeah. You want to just complete 59?
2?
Clause 59 then, yeah. 2 and
2,
3.
where it
2,
is,
3, and 4.
where it is proved to the Professional Practice and Conduct Committee by a certificate of conviction from the Registrar of the Supreme Court or the Clerk of the Parish Court or from an equivalent officer from a court of competent jurisdiction outside of Jamaica that a registered teacher, a licensed teacher, or an instructor has been convicted of a disqualifying offense, the Professional Practice and Conduct Committee shall, as soon as possible and without further inquiry, revoke the registration, license, or authorization to teach, as the case may be, held by the person. 3. Where the Professional Practice and Conduct Committee suspends or revokes the registration, license, or authorization to teach of a teacher or an instructor, the council shall forthwith notify the teacher or instructor, as the case may be, and the employer of the teacher or instructor. 4. Where upon the conduct of an inquiry into a complaint by the board of a public educational institution or other employer of a licensed teacher or instructor, the decision of the board of that public educational institution or of that other employer of the licensed teacher or instructor, as the case may be, includes a recommendation that the registration, license, or authorization to teach should be suspended or revoked, or that a condition should be imposed on the relevant registration, license, or authorization to teach, the board of that public educational institution or other employer of the licensed teacher or instructor shall, within 7 days of the decision, make such recommendation in writing to this council, specifying the reasons therefor. 5. Upon receipt of a recommendation under subsection 4, the council shall forthwith refer the recommendation to the Professional Practice and Conduct Committee for determination within 7 days. 6. Having made a determination under subsection 5, the Professional Practice and the Conduct Committee shall notify the council of its decision in relation to the matter within 7 days, and the council shall, within 7 days of receipt of the decision, notify A, the board of the public educational institution or the other employer of the licensed teacher or instructor, as the case may be, and B, the licensed teacher or instructor who is the subject of the complaint. 7. An employer who is notified of the suspension or revocation of the registration, license, or authorization to teach of a teacher or an instructor, as the case may be, shall take all necessary steps to ensure that the teacher or instructor ceases to teach for the period that the suspension or revocation remains in force.
All right. Please go ahead, Mr. Foreman.
Thank you, Chair. May I ask the rationale for specifying that the PPCC shall make a determination within 7 days upon receiving the recommendation from the board?
Sorry, Mr. Foreman, which of the 7 days you're querying?
Oh, sorry, my apologies. This is clause 59(5).
Okay.
Chair, I have some issues before 5. I don't know if I'll wait and come back to them. But if you want to take them in chronological order, I have an issue at 59.2 and at 59.4. But I'll yield to Mr. Foreman.
I wonder if this meant that the council, we're on page 8, 59.5. Is that within 7 days misplaced? Well, I think it's saying, 4 is saying the board should send its decision to the council within 7 days. The council, upon receiving that, should send it to the PPCC within 7 days, not that the PPCC should consider the matter within 7 days.
No, Minister, the provision says once the council gets the recommendation, it shall immediately refer it to the PPCC. And the PPCC is to make the determination within 7 days of receiving that referral. My query to Mr. Foreman is whether it is that the 7 days is too short or long of a notice, or it is that we should not stipulate a time frame.
I don't think so, because then if you stipulate a time frame, then what happens if that time frame happens if that time frame?
In determining the time frame too, we're looking at the provisions under the education regulations. As it is now, where a board actually conducts, where the personnel committee conducts a disciplinary proceeding, after it gives its decision to the board, the recommendation to the board, then that board shall, within 14 days after receiving the report, shall notify the teacher and the minister within 14 days after receiving that report. So
there's a stipulation in terms of the time frame that you must act,
where the board treats with a matter.
Right.
But so in referring that recommendation to the PPCC in terms of whether to impose condition on a license or so, then this it would be definitely outside of this time frame in reporting it to the minister, 1, and 2, it is not the board who will be notifying the the accused person of the decision either. So we were thinking along that line in terms of the time frame within which a response should be provided based on the recommendation made.
Please just remind me, how many members are on this PPCC? Huh? All of the entire council makes up? Oh, 5 of the total. Sorry.
What's the issue with the 7 days? What's the issue? Whether or not a stipulation should be given? That's the issue? We put it everywhere? Mr. Foreman?
Mr. Foreman, you have to come in at this again.
My apologies, but could you repeat the question or the concern that you had, please?
Oh, yes. My question was the rationale for stipulating a 7-day period for the PPCC to make a determination having received a recommendation from the school board. And in addition to that, I'll just make one comment in light of the guidance that Mrs. Sponge was provided. And the comment is that when a school board or an employer makes a decision regarding disciplinary action against a teacher or an instructor, those actions take effect as between that employer and the teacher. When the PPCC takes the decision to suspend or to revoke, etc., that's a different kind of decision, insofar as that decision will now affect that teacher's ability to practice as a teacher. So unlike the school board situation where the personnel committee is essentially acting as an agent of the school board and hearing the matter as a separate entity and then reporting to the board, you have a sort of a different intensity of consequence that arises when the PPCC takes decisions adverse to a teacher. And I think I'll just make that comment and leave that there.
But I'm still not. Are you saying that a time frame should not be stipulated where the PPCC is asked to make a decision on the recommendation?
Oh no, sorry. My initial question was why 7 days as a time frame.
As opposed to what? You want it to be a shorter time frame?
Well, in the previous draft, there wasn't a time frame, which meant that the PPCC could.
Well, in the previous draft, maybe a time frame would not have been given, but in this particular scenario where we have to go through so many layers in order for a decision to be made, I think we have to ensure that there is some level of efficiency. So the board would have heard the matter, made a recommendation to the PPCC. We wouldn't want it to be in abeyance for too long before a decision is made. I'm in agreement that some timelines should be placed there. I was hoping that you would have been proposing that the timeline should be shorter in this particular instance.
No, I wouldn't make that recommendation. What I repeat is my comment that the the decision by the PPCC to suspend, revoke, etc., the license of a teacher is one of significant consequence. And I suppose I'm curious what was thought in terms of the processes that the PPCC will employ to arrive at a decision that the recommendation of the school board should be honored. Perhaps that will help me.
Is speaking about where it is.
It's on.
Where it is proved.
It's not working. It's on. It's on.
Where it is proved by a certificate of conviction from the Registrar of Supreme Court or the clerk of the parish court or for an equivalent officer for a court of competent jurisdiction that a registered teacher, a licensed teacher or an instructor has been convicted of a disqualifying offense. So the PPCC from that shall as soon as possible and without further inquiry revoke the registration. Are you saying that, Mr. Foreman, that in that case there ought not to be an action to revoke?
Right. No, sorry, no, member. No, I think we're at the clause that speaks to the, I've lost it on my screen. The clause that speaks to the school board making a recommendation to the PPCC to have the license of the teacher revoked. Not the situation where the person has been convicted.
Have you identified which one yet? So I can just...
I think I see what I'm saying.
Sorry.
I believe he's at 59.5. I think that's where this conversation started. But as I say, I want to come back to 59.2. But again, yes. I yield to Mr. Foreman to clear up.
Yes, sorry. Yes, 59, clause 59 and clause 59.
59.5.
Right, thank you.
Remember that 59.4 says that they should specify the reasons for the recommendation. And then that recommendation will be sent to the PPCC by the council. So they will make their determination based on those reasons. So that's why I wanted to know from Mr. Foreman if it is that what's the proposed instead of making a time frame, what's the proposal?
So, Council, as it's laid out here, it appears that the board would have come to a decision, and the board informs the council. The council then sends the decision to the PPC. So, but what are they? They're going to take that and reverse it or agree with it?
Good question, Minister. That's the concern I have, which it begins at 59.4. What is the role of the council? If the professional practice conduct committee is the one to take decisions, and council pointed us to that earlier, what is the purpose of reporting to the council? And so I understand the question you're asking there, Minister. Again, maybe we just need to be clear. If it's a profession, if it's a P square, C square that takes this decision, then probably we should take the council out of it. So that again, I don't want to reopen the issue, but it appears some inconsistency. And as I said, I'd love to come back to 59.2 when we finish this. Yeah.
Chair, remember the council acts on the decision of the council in disciplinary matters. The decision of the PBCJ in relation to disciplinary matters.
If that is so, then it's not the PBCJ that takes the decision, it's the council. Just again, neither here nor there for me once we have the consistency in the legislation.
It's not the council that takes the decision at all.
Sorry, Minister?
No, it's not the council that makes the decision. It's the
so then why are we reporting to the council? Be a question. Is it not redundant then?
For them,
so let's kind of be clear. One makes a recommendation and the other acts on the recommendation. So
no cap on.
Eh?
It's not a recommendation.
I'm just trying to ascertain for us to be clear.
Yeah.
It's a clarity I'm seeking, you know.
SG has her hand up.
Thank you, Chair and members, and I apologize for being late. I have been listening to the discussion, but looking back at 59.5, I'm actually a little confused because it says the council refers the recommendation to the PBCJ, and the PBCJ is to make a determination. How exactly is the PBCJ to make a determination? Are they having a hearing? Because it cannot be that they're just going to rubber stamp whatever recommendation comes to them. That cannot be the intention. And then whatever they're doing, can they really do that in 7 days? So 5 is really a big question mark for me. It's very unclear how the PBCJ is to act in 5. How would they be able to make a determination? Is it that they have a hearing or not? Because that will then help to determine the time frame that is also in 5.
But that decision would have already been taken at the board level.
No, but
well,
that's not what it
says. That's what it says.
No,
but
Chair,
no,
the board
it
can't
says
make a
recommendation.
If you look at 4.
No, the board can only make a recommendation, but
it
the board
makes
wouldn't be able to.
A recommendation is not a decision.
No, but it says a decision of the board.
5 says upon recommendation, upon receipt of the recommendation. It didn't say a decision. Because if there is a decision,
if you look in 4 and 4 above, you'll see it says the decision of the board.
And this is exactly what I'm saying. 5, I'm very confused. It makes no sense. It's not flowing. Because looking at 5 does not really, it doesn't flow. There's no consistency. Why is the matter being referred to the PBCJ in 5? If a decision has already been taken, what would be the role of the PBCJ?
So SG, I totally get the concern. I'm trying to work through it as well. Because from my understanding of the legislation before us, there are certain matters that the PPCC or the council then would be seized of that a board may not have the jurisdiction to preside over. So in a situation where matters are before a board that really are for the council or the PPCC to adjudicate, then the board would have to make maybe not a recommendation, but the board would probably have to refer those to the PPCC for determination. Now, I do appreciate the natural justice reference or the implication that something more would have to be done from the PPCC to make a determination. And that is where now probably we'll need to make some inclusions here. So the board of the school is not able to make a decision on behalf of the PPCC. So that is clear to me. But where a particular issue or concern is raised at the board level that should really be for the council or the PPCC, then it has to be referred to the PPCC, which is what I gather is the intention here. Now, what happens after that, I think, is where the SG is having a difficulty. But I think we may still need to reword these provisions to be clear.
All right, Dr. Gordon.
Thank you, Minister. Good evening, everyone. I'm sorry I can't turn on my camera because of the limited bandwidth I have. If we look at the process, a board can fire a teacher without requesting that the person's license be revoked or suspended. When the board gets to that stage where it thinks or it has concluded that this person's license should be revoked, and then make a recommendation to the council takes it from there, gives the recommendation to the PPCC for investigation, inquiry, whatever they do with it. The PPCC comes back to the council with a response, and the council then gives that response to the board, because no other body can revoke the license of a teacher but the council. PPCC cannot do that. So information must always go back to the council. Thank you, Chair, Minister.
But that means
Sorry, Minister, did I hear correctly from...
So that means in 4
instead of... that the PPCC can't revoke the license?
So it is a matter for the council to revoke the license, but the PPCC does the investigation, etc., and inform the council, gives a report to the council, and the council carries out the act of revocation.
I am 100% with you, but I believe we have moved away in these clauses from that principle.
All right. So first
I'm not clear. I'm not clear, sir, what you just said. I don't know of any other section in the or clause in the act that would say otherwise.
Well, I believe that in 59(4), where it says, whereupon the conduct of an inquiry into a complaint by the board of a public education institution or the employee of a licensed teacher or instructor, the decision of the board, shouldn't that be the recommendation rather than the decision? I don't know. I'm asking.
Chair,
please?
Chair, may I?
Sure.
So that's the problem. So we start with 4 that talks about not just that the board is going to take a certain type of decision, but on top of the decision, it makes a recommendation. So what it says is it takes a decision on whether the complaint, I guess, is founded or not. But if there is on top of that decision, if there is a recommendation that the registration license or authorization to teach should be suspended, or that a condition should be imposed, that issue is then to be referred, it appears, to the PPCC. It is that recommendation that is then referred to in 5. And that recommendation in 5 is submitted to the PPCC for determination. Now, when I see the words for determination, that means a decision. And then when you go to 6, it says, having made that determination under 5, the PPCC then notifies the council of its decision. So I hear everything Dr. Gordon is saying in terms of what the process should be, but that is not what is reflected on the paper. I also think it's very confusing that in one provision you're talking about decisions and recommendations being made. I think it all has to be broken up. I think the steps need to be identified and clearly demarked. They can't be joined up the way they are right now.
Madam Chair, based on what has just been said, I think we just need to allow Ms. Sherland and the technical team just to redraft that section to break it out as was discussed. Because I understand where it's coming from. I didn't see it for myself at first, but I now understand what they're saying. It needs to be broken out a little bit. Madam Chair, I have another question in that same section. When it says at 6 and 7, an employer who is notified of the suspension or revocation of the registration, license, or authorization to teach of a teacher, as the case may be, shall take all necessary steps to ensure that the teacher ceases to teach for the period. Somewhere, even if not in the legislation, in the regulations that will accompany it, we have to think about the time it will take for a replacement teacher to be found. So it is important somewhere, I'm not sure where, if it's the regulations are here, that is considered, because you would not like to see a teacher being suspended and there's no replacement found.
Chair, can I ask Senator Campbell Rodriguez, just to pause on that so we could complete the conversation we're just having about the relationship between the PPCC and the Teachers Council in light of the points raised by the SG and in light of part 2 of this legislation, clauses 6 and 7 in particular, which establishes the Jamaica Teaching Council to be the one who take the decisions on revocation, etc., which is why I had the difficulty with the PBCC being given all of this power and not coming back to the council, and I think we're just running into that. So if Senator Campbell Rodriguez just hold her point, so we just clarify for guidance of the technical people the issues we're dealing with there.
All right, so we'll ask our technical team to clarify clause 59 and come back to us.
So, Minister, if you're going to do 59 in total, may I ask that we get from the Attorney General's office a comment on 59.2 relative to the issue of natural justice and clause 16.2 of the Charter of Rights? Because it appeared to me that 59.2 eviscerates natural justice as it is there now. And so I'd appreciate a comment from, if not necessarily now, but at some point, as to whether this fits into 16.2 of the Charter of Rights.
So, is the member saying that for 59.2, where a court deliberates?
Look at what a disqualifying offense is.
Where is that? Okay, on the Clause 2 interpretation.
Means an offense for which the penalty is a term of imprisonment of 2 years or more.
Right. I guess
16.2 he's referring to says, in the determination of a person's civil rights and obligations or of any legal proceedings which may result in a decision adverse to his interests, he shall be entitled to a fair hearing within a reasonable time by an independent and impartial court or authority established by law.
so. After the Supreme Court or Parish Court hears a matter and a decision is taken, is the member saying that we should now additionally, from the PPC standpoint, have another hearing?
Yes, an opportunity to be, an opportunity to be heard. There could be many a factor. Because this is not just about the Supreme Court and the Parish Court in Jamaica. It may be something about a Florida court, a court in Boston, and there may be information that is helpful. For example, it may be that the matter has been expunged.
But it says convicted. It says convicted, though.
Shouldn't the committee be allowed to hear from the person? But what?
The provision mentions the person being convicted of a disqualifying offense.
Yes, and what
so
is the person appealing that decision?
A hearing would have taken place in relation to that disqualifying offense.
And what if the person is appealing the decision?
Which
So in other words, what I'm saying is that person should be told, this is so, we have this from Florida, or we have this from the St. Mary, or the Supreme Court, and be allowed to say, yes, this is so, or not. But to say that person, and it is the Parliament intent that that person should be silent by the fact that there's the production of a certification to the committee is just sufficient to say you're revoked. I don't believe it fits into 16.2, which is why I asked for the opinion of the Attorney General's chamber on this clause. It may be persuasive evidence, It certainly will be, but it shouldn't be that there's no hearing. That would be my view.
Chair, 61.2 says the 61.2 of the bill. It says the revocation of registration, license, or authorization to teach by the council in relation to a disqualifying offense remains in effect during an appeal. And I'm seeing addition to the tribunal. So I'm not sure if that answers
why would you say tribunal
question.
versus PPCC? Council? Why would you say tribunal versus PPCC?
Because once the matter is determined, the next stage is to appeal.
The PPCC is the tribunal, right?
Once it is determined at first instance.
Sorry though, Chair. No, an appeal is not automatic.
No, it would.
Right.
No,
So I'm saying you can't. I'm not sure I'm following that logic because it's not an automatic process.
So where there's an appeal, I'm not sure if it is that we need to rephrase 61.2. But where there's an appeal.
But that does not address the issue that is being raised. And just to respond, that the chambers will respond at the next meeting on the issue raised.
Which one of the issue, SG?
Well, I thought it was what was discussed was 59.2 and the concern about 59.2.
Right, and right.
Right,
well,
and I'm saying I don't think 61.2 is response to the concern, but Senator Brown had indicated that we could respond and not necessarily today, and we're taking him up on that offer. So I'm suggesting that we would respond at the next meeting of the committee.
But 61.2 speaks to the matter of the appeal, where it says, it was raised that, if I remember well, Senator Brown said, what happened if the person was appealing? 61.2 is talking about the fact, it says, the revocation of the registration, license, or authorization to teach by the council in relation to a disqualifying offense remains in effect during an appeal. So that's why 61.2 was referred to.
I thought he meant an appeal of the conviction, not an appeal of the revocation. But I'm not sure.
That is correct. That is correct.
Okay.
It's an appeal of the conviction, right?
But as worded here.
No, the appeal in 61.2 is dealing with the appeal of the revocation, not the appeal of the conviction. This bill wouldn't deal with appeals of a conviction under a criminal court.
What I get Senator Brown to be saying is, whilst there's an appeal of the conviction itself,
right. Exactly.
61.2 speaks to the revocation.
Yes,
but
exactly.
Senator Brown was saying that there ought to be another chance given for the matter to be heard whilst there's an appeal of the conviction.
Well, the section doesn't say that. 61.2 is not written. It is written where you can interpret it either way. And that's my non-lawyerly reading, so correct me if I'm wrong, but if we look at it, it says, in relation to a disqualifying offense remains in effect during an appeal. It doesn't, unless I'm not understanding. So I know what the intention was, of the subsection. I know the intention is for it to refer to the appeal of a revocation.
Senator, the draft I have, which was recently circulated, has the words "to the tribunal" inserted.
I don't have that draft.
Okay, so this is a draft I have working from. I think it was circulated very recently.
The big paper. Okay.
But Chair, based on how the provision is read, I understand what Member Brown is saying in relation to what if there is an appeal of the conviction, but the provisions itself says once they are convicted, the license is to be revoked. So if it is that they're appealing their conviction and their license is revoked, they would have to also appeal the revocation.
And that's where I jumped in to say that's not automatic. Nobody is forced to appeal anything. But Chair, I go back to, we would like an opportunity to do research. Let me explain why. This is a provision that you will see in the police service regulations, the public service regulations, and so on. It's a provision that predates our Charter of Rights, where it allows for persons to be dismissed once there is a criminal conviction. But in light of our charter, we would like the opportunity to just look to see what the case law is telling us. So again, I'm just asking for that opportunity.
And may I add in support of your position, SG, the fact that the Public Services Commission, as I think it's 2018 guidance to the public sector in respect to that, and they cite 2 cases. One involving our prison warden, I believe, I think his name was Al, who was absent for a long time from work, and the court ruled against him. And then there's another case, I can't recall immediately, no, but the Services Commissioner sent out those guidance to the public service. So it is against that background that, in which I know the public service has said they are moving away from that old approach to say a hearing must be had. So I share the view that the AG's department ought to be given the time to look at it, because I'm aware of the Public Services Commission guidance to the public service on this matter, because I recently saw that guidance. So I'm raising these issues from experience and from knowledge. Don't always say the source of it, but it's not to be contentious. But I believe the Charter of Rights, and it's the Chief Justice who said there are many of our laws now that are in conflict with the Charter of Rights, and this might very be one of them. So it is against that background that I'm saying, give the Attorney General's office a time to comment. If this is consistent with 16.2 of the Charter of Rights, it's new grounds. So let's do it in the same way that Senator Campbell Rodriguez wishes to get some guidance on another matter earlier. I believe we should, since this touches and concerns the Constitution of Jamaica.
So we will await the SG's research on the matter on 59.2, looking at the Charter of Rights and so on, to come back and help advise us on this cause. Thanks. For the next clause is 660. We don't have that much to go through. Can we just run through clause 60? Clause 60.
Effect of suspension of registration, license, or authorization to teach. 61. Where a suspension relates to a registered teacher, licensed teacher, or instructor who has been charged with a disqualifying offense, the suspension remains in force until the earlier of the following occurs. A, the Professional Practice and Conduct Committee cancels the suspension, or B, the charge that forms the grounds for the suspension is dealt with in any of the following ways. 1, the charge is withdrawn, or the prosecution for the offense charged is discontinued. 2, the person dies without the charge having been determined. 3, the charge is dismissed by a court. 4, the person is discharged by a court following committal proceedings. 5, the person is acquitted of the offense by a court. Or 6, the registration, license, or grant of an authorization to teach of the person is revoked because the person was found guilty of a disqualifying offense by a court. For the purposes of this act, a person whose registration, license, or authorization to teach is suspended is deemed not to be registered, licensed, or authorized to teach for the period of that suspension. 3, a person whose registration, license, or authorization to teach is suspended shall not start or continue to practice as a teacher or instructor in a school or other educational setting to which this act applies. 4, at the end of a suspension under this act, the person whose registration, license, or authorization to teach was suspended shall be reinstated as a registered teacher, licensed teacher, or instructor, as the case may be, and is considered to be registered, licensed, or authorized to teach on the same conditions that were previously imposed. Previously imposed on the registration, license, or authorization to teach, unless otherwise determined by the council.
Where a registered teacher, a licensed teacher, or an instructor has been discharged or acquitted of a disqualifying offense for which a registration, license, or authorization to teach of such person was suspended, that person shall be A, reinstated as a registered teacher, licensed teacher, or instructor, as the case may be, B, reimbursed as prescribed for the period of suspension, and C, considered to be registered, licensed, or authorized to teach on the same conditions that were previously imposed on the registration, license, or authorization to teach. And Minister and members, you will note that B is in square brackets because the decision has to be made whether this reimbursement, or perhaps I should say, I'm drawing to your attention the fact that reimbursement will be fleshed out in regulations. So that is why it says as prescribed, reimbursed as prescribed.
To understand that what may appear in the regulation is a prescribed format for the reimbursement, because it says for the period of suspension, it assumes in my mind that it would have been a reimbursement to what the person would have lost during that period of suspension. I'm trying to relate to the connection between being reimbursed for the period to recover loss as opposed to what is going to be prescribed.
I just want to know what's in the prescription.
I think it would be good at this juncture to ask Dr. Gordon to comment on what is envisioned for that reimbursement that will be set out in regulations.
Dr. Gordon?
Yes, Chair. For the period of time a person's salary or portion of salary has been held, that person should be reimbursed all of that money should the person be considered innocent or the person is not guilty of the act. All of this person's salary and should be paid to that person. All the salary that has been lost.
So, Doc, does that mean that we don't need to say as prescribed? Because since the person will be reimbursed all of the salary for the period. Very well.
That to me is a legal term. I don't know about whether it's prescribed or not prescribed, but the person gets his or her salary according to what he or she had lost during the period.
Very well. So we don't need as prescribed.
Yeah. The question, Chair. We have two sets of people from which the teachers may flow. From other employer, which is not the government, who makes the payment. And let's say it's a school, Brownsville High School, independent school, private, maybe church owned or so. Who makes the payment in such case?
It would be any person who was responsible for paying the teacher a salary. So whether it's a private school, public school, church school, it doesn't matter. Anybody who is responsible for paying the teacher a salary will now have to pay the teacher the salary.
Yeah, but let me try and see. So here's a private school who know as this teacher suspended because of a complaint made by somebody, anybody. The school has to find somebody to replace that teacher in the interim. The teacher is acquitted, and then you turn to the school and say, you know private school must make that payment to that teacher, even though you didn't make the suspension, you didn't cause the suspension. Does that sound fair? I mean, I'm for the reimbursement, don't get me wrong. The question is, we need to find a way to fashion this so that it appears fair, because I can see people complain and say, we had nothing to do with the person being suspended. It is you, government, who took it upon yourself to suspend the person. Why should we, the private school, be the one called upon to make the payment?
Okay. But the person,
something we need to give thought to.
But Member Brown, the person would have been paid otherwise if they were at the school. The fact that they're suspended, I don't know.
Yeah, but Minister, the school would not have been paying two people at the same time.
Go ahead, SG.
Thank you. I'm trying to find the provision that allows for the withholding of the pay. I hear everybody talking about reimbursing the pay. Can somebody direct me to the provision that allows for the withholding of the pay?
Sorry, repeat, Soljan.
Which provision authorizes the withholding of the salary when the person is on suspension? Everybody's talking about reimbursement. I'm asking which clause allows for the pay to be withheld.
Am I hearing the SG to be saying that you need such a clause? If you're going to take away people pay, you need to give yourself that power in the legislation?
Well, I will go further. We have case law that says that for interdiction proceedings in the public service, there must be a hearing before the person's pay can be withheld. It doesn't have to be an oral hearing, it can be a paper-based hearing, but the court has held that that is required as a matter of fairness. So we have in the public service regulations and in the police service regulations, although they're not identical, it allows for what's called interdiction. Interdiction is akin to suspension. In interdiction, it specifies that person's pay can be withheld. And that it still is being done almost routinely when persons are being charged with disciplinary offenses. However, what the court has gone on to say is before you can actually withhold the pay, there has to be a hearing. But the reason the persons are able to even withhold the pay is because both in the public service regulations and the police service regulations, it allows for it. And it sets out the different matters that you consider or the type of infringement which would lead to the pay that can be withheld. So for instance, I think if it's something related to fraud, it may be a quarter. I don't have it in front of me now, but it gives you a sort of scale. But it is provided for in law. Why is this important? Because we have section 15 of the Constitution, which talks about compulsory acquisition or taking possession of property. Money is property. And so you can do that by way of things like a court process or so on. And this is why the legislation usually provides for the mechanism for the actual withholding of the pay. So again, that's why I'm asking, we're talking about reimbursement, but I don't see anything in here speaking about the actual withholding of the pay and the process to do that.
So the AG is calling in the Faith Webster case.
That is correct.
And Minister, while that is being contemplated, I did mention the Services Commission circular. So for the record, this circular number 276 of 2017, 1st of November 2017. And the cases that it cited was Alfred McPherson versus the Minister of Land and Environment, and the Erling Hall versus the Public Services Commission. Just for information that it may help us to see how these issues are treated now by the Services Commission.
Sure, sorry. If through you, can you just repeat the number of that circular, please?
Circular?
Yes.
275, OSC 275 of 2017, 1st November. Yeah.
Madam Chair, can we ask Ms. Sherland just for a quick response on this? Since we know now that we don't have that section that speaks to interdiction in the Act, how can it be remedied in the Act now?
Well, considering that it's a substantive issue, so then I would have to look at the provisions, similar provisions, if they exist in the law now.
The Education Act, right, Ms. Gordon-Jones?
So that's the problem, though, Chair. Yeah. The existing provisions are not, well, the court has basically ruled that the existing provisions are not consistent with the Constitution. That's the rub. So we have these older older rules, older laws. And I suspect the education regulations were basically modeled off these pre-independence regulations, because as you're aware, and your committee members would be aware, public service regulations and the police service regulations are 1961. So they even predate our constitution. And then we modeled a lot of laws off these older regulations, but we now have more recent decisions. So like that Alfred McPherson decision is even one of the older ones. And we have a plethora of decisions going through making rulings, decisions on a number of these provisions. And so when we keep replicating them without taking into account the guidance from the court, we're going to run into problems. I don't know of a precedent to give Mrs. Douglas Sherlon, because everything is usually modeled off the older legislation. I think it would be a matter of us trying to craft it or assist. She will have to get instructions. This is Mrs. Douglas Sherlon would have to be getting instructions as to what to put in. Now, I don't know if you actually want to use the terminology interdiction. You may still want to go with suspension, but you have to recognize that there would be a process to be able to withhold pay. And so I think what we can do is try to work with Mrs. Gordon-Jones and Dr. Gordon with legal reform in trying to assist the ministry in providing instructions to Mrs. Douglas Sherlon, because she will need to be provided with drafting instructions on this point.
Mind to it, because Chair, there would have been no reference to the suspension and the holding of pay in the first instance. Right. And then we speak about the reimbursement, so there has to be a connection. Right. But I'm looking back at these clauses, and it appears that they need to flow in a manner that we interchangeably use suspension and revocation. Yeah. And so we need to be sure that, whatever we are saying, it is clear in terms of the action that needs to be taken. Solgen, you raised a very important point that there are a number of case laws and decisions and judgments that have been made, and we have not aligned our legislation in keeping with those decisions because time has evolved. And we're continuing the use of old provisions against changes that would have been, established based on judgments. And so it's something that we need to determine and to examine in all our legislations.
All right, so committee members, we are going to pause here in recognition of some sticky matters that have come up. Going back to 59, or 58. From clause 58, number of issues there. Clause 59 as well. Or did we take, I'm sorry. Yeah, in terms of the time frame and so on. So the next time we meet, we will,
Just 1 minute before you wrap up, I think Senator Gale needs to make a very valid point before we close. So at the next meeting, we can have some kind of a conclusion or solution to it.
Unfortunately, I didn't hear what Senator Gale said because the system froze a while ago and actually came offline. So, but probably Senator Gale can on Friday tell me what is it that you're saying.
Senator Brown, he's looking at something now, but the point he was making was the same, similar to what the SG made. In when she spoke about the fact that the case law versus the old laws.
Yeah, all right. I did hear that part. Well, we froze for a little while.
So what? So
Thank you.
He's about to make another point, but he just needs a second.
All right, so let's start at the beginning. It says at 59.2, where it is proved to the PPCC by a certificate of conviction from the Registrar of the Supreme Court or the Clerk of the Parish Court or from an equivalent officer from a court of competent jurisdiction outside of Jamaica, that a registered teacher, a licensed teacher, or an instructor has been convicted of a disqualifying offense, the Professional Practice and Conduct Committee shall, as soon as possible and without further inquiry, revoke the registration, license, or authorization to teach, as the case may be held by the person. So from that, I gather that once there's a conviction, there is a revocation of the person's registration. All right. So let's turn now to 60, subsection 5. It says, where a registered teacher, a licensed teacher, or an instructor has been discharged or acquitted of a disqualifying offense for which the registration, license, or authorization to teach of such person was suspended. That's where we're having a problem. Because once there's a disqualifying offense, it should be a revocation and not a suspension. Where in the legislation does it allow for a suspension for a disqualifying offense? Where? 59.1? Where a registered teacher has been charged for disqualifying offense. That's a charge. So
that's a charge.
So members, there is much to be considered for starting from 58.
We should.
Right? Clause 58.
Right, and then that now would flow into the reimbursement for the period of suspension because the person would have been revoked. The license would have been revoked. Right, so I think this just needs to be reviewed.
So 58, clause 58 and 59 really need some reviewing. And 60 as well. So we'll just start at 58 when we meet for the next meeting, which will be on April 6, 2023 at 10 a.m. 5th? Sorry, April 5. Yeah? Easter.
It will be April 5 or 6?
5.
5 at 10 a.m.?
Yes. That's why we do 10 a.m. Yeah. All right, members, any other business? There being no other business, the hybrid meeting of the Joint Select Committee on the Jamaica Teaching Council Act 2022 is hereby adjourned.
Seconded, Madam Chair.
Thank you so much, members and the team from Parliament. Thank you.